I'm very grateful to the Carleton University Department of History and to Dominique Marshall for the invitation to be part of the 2020 Shannon Lectures in History series, and to talk to you today about the very modest and simple topic of the history of privacy and the future of artificial intelligence. As AI technologies transform our society and our economy, we're at a moment of unparalleled public debate over and government and judicial interest in privacy law. The EU's General Data Protection Regulation has set new international standards for human rights-based data protection, and it's also brought issues related to AI and automated decision-making under its broad framework. Spurred by international developments, federal and provincial governments in Canada have started to respond. At this very moment, there's an important bill to reform public and private sector data protection laws before the Assemblée nationale in Quebec, a review of data protection legislation in BC, consultations about a new private sector data protection law for Ontario, and the possibility of a federal bill in the next few weeks to reform the country's private sector data protection law. There has also been a flurry of recent legislative activity around the sharing of intimate images online and cyberbullying with new criminal provisions and civil recourse. The common law of privacy is also undergoing a considerable growth spurt. Although AI is not the only reason for all of this activity, it's part of the landscape of technological change that is driving it. There are two broad dimensions to the relationship of AI to privacy. AI will undoubtedly feature in new technologies of surveillance and control. For example, the pandemic has created new markets for AI-enabled home surveillance technologies to gauge the remote performance of workers and students. AI is behind powerful facial recognition technologies that are increasingly used both by public and private sector actors. Some AI technologies are directed specifically towards assessing, detecting, controlling, and even manipulating individuals. Thus, many AI technologies will raise significant privacy issues in their own right. At the same time, all AI technologies are data thirsty. Those that relate to humans require a vast and steady supply of personal data. AI will therefore feed upon the massive stores of data being collected in real time in a multitude of contexts. There is already much work being done to address privacy and ethical issues in using personal health information in healthcare AI applications designed to save lives and improve outcomes. Governments are looking at ways to deploy AI in a range of decision-making contexts that will impact individuals. We also hear of the use of personal data in a growing array of consumer-oriented AI technologies. The relationship of AI is therefore bidirectional, with AI technologies creating new privacy risks and harms that will have to be addressed, and with existing flaws in how we govern the collection and use of data, raising concerns about the legitimacy of the data that underlies the technology. Just last week, the Privacy Commissioners of Canada, BC, and Alberta issued a report on a joint investigation into the practices of Cadillac Fairview shopping centres at a number of malls across Canada. One issue involved the collection of face scans from mall visitors who looked at information panels. These scans were analyzed using facial recognition technology to determine certain demographic data such as age and gender. The commissioners found that although Cadillac Fairview did not make further use of the data collected, its service providers stored facial recognition data derived from the images for no apparent purpose and with no justification. The commissioners also found that Cadillac Fairview did not adequately address the collection in their privacy policy and did not adequately obtain consent. From a history of privacy and technology point of view, this very recent report is an opportunity to pause and think about how we arrived at this moment in time. How is it that we can go to the mall to shop and without being aware have our biometric data analyzed and stored for potential future use in AI analytics? How is it that complaints about such practices are framed in terms of whether we have adequately consented to the collection and use? And are we facing a future in which simply entering public or semi-public spaces will amount to consent to the harvesting of data about us? These questions go beyond the data protection laws that the commissioners were interpreting and applying. It is these bigger questions about privacy in an AI era that I wish to explore today. I will emphasize the concept of privacy as a human right and will distinguish it from the consent-based models of data protection that are too often conflated with privacy. Data protection is a system for balancing privacy rights with the needs of governments and businesses to access and use data. But the human right to privacy exists above and beyond data protection law. Data protection law is a tool to protect privacy. It does not itself define privacy. And if data protection laws are meant to create a framework to balance privacy and other interests, then their failure to properly do so is a breach of the right to privacy. Most would agree that consent-based data protection models are profoundly broken in a context in which more and more services have moved into the digital space, collect vast amounts of data, and do so via privacy policies that are too long and too complex to read, too vague or inscrutable to decipher, and that are often presented as take it or leave it arrangements. In an increasingly sensor-laden Internet of Things environment where the devices that we carry, wear, or have implanted in our bodies are harvesting and transmitting data, where our connected vehicles and smart device-laden homes are similarly collecting and sharing data, and where sensors in the urban environment are likewise always on, it's hard to have any faith in a version of data protection that is predominantly consent-based. What I will argue today is that the concept of privacy is neither limited nor defined by the narrow data protection understanding to which it's too often reduced. I'll argue that we have a role in reconstituting and affirming privacy as a robust and meaningful value that is both a human right in its own, on its own, and one that is intrinsically linked to many others. Rather than declare that privacy is dead because technology has profoundly changed interactions in our current context, we need to think even more about the core values we seek to protect through privacy and about how we can shape laws and policies that will recognize and protect those values. To get us there, I draw some lessons from the history of privacy in Canada. I should note as well that with only limited time, the history I recount will be selective and will be predominantly focused on common law Canada. The history of privacy in Quebec is somewhat different, and there are interesting lessons to be learned there. The fact is that there are many histories of privacy in Canada, and I'm going to be telling only one of these today, perhaps even only a fragment of it today. But my goal is to demonstrate two broad points. First, there's a long-standing and important link between privacy and technology. The evolution of technology has inevitably shaped how we interact with our world and with those around us. These interactions in turn shape how we think about privacy. Technology has in fact been a primary driver of changes in privacy law over time. It's entirely natural, therefore, to think of the history of privacy in step with the future of such a transformative technology as AI. Second, privacy is deeply embedded within its social context. Not only does this shape and limit the right, but it reveals how the right is also shaped and limited by those with the power to set those boundaries. Debates about equality and the representativeness of our legislatures and the judiciary are also therefore part of privacy, since the privacy law that we have or do not have is a product of acts of the legislature and decisions of judges. In our almost dystopian present, the growing susceptibility of governments to corporate influence and the use of digital technologies to manipulate individuals and to impact election outcomes are also factors that loop AI back to privacy in sometimes highly problematic ways. There are many moments at which a discussion of the history of privacy could start. I've chosen Simain's case, an English decision from 1604, and one that's part of Canada's received common law. It's been frequently cited in Canadian case law and was the basis for pre-charter privacy protection, where it was referred to by former Supreme Court of Canada Justice Gerard Laforêt as a, and I quote, a right devised for the protection of individual security and privacy against state power. Simain's case is often cited as the origin of the statement that a man's home is his castle. The significant part of that statement was the idea that a man was sovereign over his own home in the same way that a king is sovereign. It set the boundaries against intrusion. Common law principles such as that from Simain's case remained the heart of Canadian privacy law for a long time. Following the Second World War, Canada acceded to international human rights obligations that included privacy. For example, in the 1948 Universal Declaration of Human Rights, it provides in Article 12 that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. This right is reproduced verbatim in the 1966 International Covenant on Civil and Political Rights. The articulation of the right is similar to what we see in Simain's case, although the expanding domains of privacy extend beyond the home to family and correspondence, as well as aspects of reputation. The right, I note, continues to be expressed in gender-specific terms. If you're inclined to forgive this as a linguistic anachronism, please don't. The articulation of privacy, like that in Simain's case, is thick with notions of gender, property, privilege, and status. It and the laws and jurisprudence that shape these articulations were premised on the rights of privileged members of society, property owners, to control their property and to protect their families. These articulations erase women and children and are silent as to the dynamics of race and class when it comes to concepts of privacy rooted in private property. Unlike the US, which had a constitutional right to be free from unreasonable search or seizure in 1791 in the form of the Fourth Amendment to the US Bill of Rights, Canada's privacy protection derived from British common law. A formal constitutional right to be free from unreasonable search or seizure only arose in 1982 in the Canadian Charter of Rights and Freedoms. This charter right has become a central element in defining citizen rights of privacy vis-a-vis the state in Canada. It will be important also in determining the extent to which AI technologies linked to law enforcement conform to privacy rights. The domain of Section 8 is primarily, though not exclusively, the criminal law. Criminal law in which individuals are confronted by the state has always been an important site for the development of some of the principal limits on state action in the name of privacy. Certainly, provisions regarding search warrants and the accompanying judicial oversight set limits to intrusions upon domestic castles. Technology has spurred important changes to the criminal code to address privacy between citizens and the state. In the 1970s, for example, important new amendments governed intrusive new wiretapping technologies. Yet not all privacy law involves the relationship between individual and the state. A classic early articulation of the legal right to privacy outside of this context comes from US jurists Samuel Warren and Louis Brandeis and their famous 1890 article titled The Right to Privacy. The article essentially argued for a new tort recourse to address incursions on privacy from other people and from corporations, so something other than the state. The authors characterized the right to privacy as an emerging and evolving right, noting that, and I quote, political, social, and economic changes entail the recognition of new rights, and the common law in its eternal youth grows to meet the demands of society. In words that we might use even today, Warren and Brandeis wrote, "Recent inventions and business methods call attention to the next step which must be taken for the protection of the person and for securing to the individual that which Judge Cooley calls the right to be let alone." Even in 1890 then, the right to privacy and its evolution were closely linked to the development of technology. The privacy crisis that prompted Warren and Brandeis to write their famous article was what they perceived as the excess of the press and the ills of gossip that intruded upon the private lives of individuals. Think of this as the 1890s version of Facebook. These concerns were driven by the technology that enabled the burgeoning print media, as well as the technology of photography that allowed the capture of personal information in new ways that could be shockingly revelatory. At the heart of Warren and Brandeis's argument for recourse in common law for breach of privacy was the idea that the individual had a right to control how their thoughts, sentiments, and emotions would be communicated to others. In other words, at the core of their argument was a notion of human dignity and autonomy. The right to privacy that later emerged in US law therefore filled a space in the common law and addressed private privacy harms, those that did not involve the state. Change of this kind was much slower in Canada, although 4 provinces acted over the period between 1978 and 2002 to create statutory privacy torts to fill the same gap. It was only in 2012 that the Ontario Court of Appeal recognized a common law tort of breach of privacy in Jones versus CIGI. The new tort was quaintly and problematically labeled intrusion upon seclusion, again, evoking that, man's home is his castle context. And it was very carefully constrained by the court. Since that time, the privacy tort has picked up steam, quite possibly because of an unmet need for redress and because of the many ways in which technology impacts interpersonal privacy. Many of the tort cases that now arise, unsurprisingly, involve technology, including issues of audio and video surveillance and digital snooping. The tort is also raised in class action lawsuits involving massive data privacy breaches. In just the last couple of years, different Ontario judges have also recognized new branches of the privacy tort involving disseminating privacy facts and/or false information about individuals. These torts are particularly important in addressing the ways in which uses of social media can impact privacy and reputation. I started this talk by noting that privacy is about far more than just data protection, and I've now touched on privacy and relationships between individuals and the state, as well as interpersonal privacy. The rise of technology led in the 1970s and 1980s to the creation of a new body of privacy law, and that is data protection law, aimed at achieving privacy in a context in which personal data has become increasingly important to businesses and governments. In 1980, the OECD guidelines on the protection of privacy and transborder flows of personal data set an international standard for data protection that is credited with providing the framework first for public sector data protection laws in Canada, and eventually for private sector data protection laws such as Canada's Personal Information Protection and Electronic Documents Act. Although the extraterritorial influence of the EU's 1995 Data Protection Directive was a strong motivator to address the private sector context. Both the OECD guidelines and the EU directive underscored the growing importance of the flow of data across borders in support of international trade and commerce. It's important to note that data protection laws do protect data, but they do so in order to enable their use by governments and the private sector. In the private sector context, an important goal is to facilitate their flow across borders in the interests of global trade. Today, another important goal is to facilitate data flows in support of AI. Data protection law began with a technologically modest data collection context that has since been growing like some science fiction organism that devours everything around it. Such laws were consent-based in order to recognize the autonomy of individuals to decide who could use their data and for what purposes. They remain consent-based today in a context in which data collection and use has far exceeded the capacity of individuals to manage. That is why today data protection laws must not just be amended, they must also be overhauled. Many private sector companies collect vast quantities of data about us from a growing number of technologies in our physical and digital worlds. These data are used to profile, predict, and manipulate, often in the service of creating needs that we didn't even know we had, and then attempting to meet them. This massive collection of data has been enabled by weak data protection laws and by a failure to connect the dots between data protection and fundamental human rights. Reform of these laws is critical to the legitimacy of AI technologies. Up to this point, I've talked about three broad domains of privacy law. These involve the relationship between the individual and the state, interpersonal privacy, and data protection. From the point of view of legal development, these have been separate domains of privacy, but the lines can blur in important ways. One of these relates to the extent to which data in the hands of the private sector is accessible to the state. Data protection laws were framed to allow private sector actors to share information with authorities in order to aid in investigations, and criminal law contains provisions that set the parameters for state access to data in the hands of the private sector. But these provisions were never calibrated for the volume and detail of data that are actually collected by the private sector. As a result, vast quantities of data collected by the private sector are only ever a production order away from state authorities. And reflecting how the law falls behind technology, this data is accessible by the police at a lower threshold of scrutiny. It is considered to raise fewer expectations of privacy since it is information already in the hands of a third party, thus outside that private property dominion model that is so favored by the archaic roots of privacy. To add insult to injury, privacy policies on which our broken data protection consent-based system rests are often used to demonstrate that we've already consented not just to sharing the information with a third party, but to accepting whatever that third party decides to do with respect to sharing that information with authorities. If the state is only ever a production order away from the massive amounts of data collected by private sector companies in our increasingly connected environments, then there really is little practical difference whether the state collects this data or the private sector does. The individual state relationship collapses into the far less carefully scrutinized relationship between corporations and citizens. Just as the privacy context is changing, so too is our understanding of the human right to privacy. The same changing privacy context that led to the era of data protection legislation also led to the UN Human Rights Committee in 1988 to interpret Article 17 of the International Covenant on Civil and Political Rights as requiring the protection of individuals from interference with their privacy, not just by the state, but also by individuals and corporations. And as the ways in which data are used gave rise to increasing concerns about privacy, the UN General Assembly in 2013 adopted its resolution on the right to privacy in the digital age, which reaffirmed the rights set out in Article 12 of the Universal Declaration of Human Rights and Article 17 of the International Covenant. It noted that the exercise of the right to privacy is important for the realization of the right to freedom of expression and to hold opinions without interference, and is one of the foundations of a democratic society. This is a reframing of the right to privacy in terms of its fundamental values and its relationship to other rights, in response to the novel ways in which privacy is threatened and invaded, and the disturbing harms to other human rights and civil liberties that flow from the misuse of personal data on a massive scale and across public and private sectors. I have tried to outline for you the three broad areas of privacy law and to provide at least a brief glimpse at how the law evolved. I want to take a moment now to talk about the biases of privacy law. There's much talk about the need to be attentive to biased data and algorithms in AI, and rightly so. I want to suggest that we also must reflect on bias in the laws and legal institutions that will hold these technologies to account. An important trajectory for privacy law has been the shift from privileged masculinist views of privacy to contested relational privacy understood in terms of differential impacts. In a case from the 1960s called Bolduc and Bird versus the Queen, a doctor and his friend were initially convicted of indecent assault after the doctor explained to a female patient that his pal was a medical intern, thus obtaining her consent to have him present in an examination of what the court called her intimate parts. So, the doctor and his intern were initially convicted. The men appealed their conviction to the Supreme Court of Canada, where the majority of the court overturned it. In their view, since there had been no touching by the friend, there was no assault. And I quote, "The friend was acting as a peeping Tom, and such conduct is not an offense." Okay. Voyeurism became a crime in 2014 in Canada. I want to underline here the gaping hole in privacy law that for so long failed to address an invasion of privacy disproportionately experienced by women and children. It was only the amping up of voyeuristic powers by way of technology that pushed Parliament to act. I also want to underscore the role of gender bias in shaping whose privacy is protected and how. As we begin to make laws to define the circumstances in which certain AI technologies may or may not be deployed, we will need to be attentive not just to the biases that can so easily be embedded into the algorithms and that are reflected in the data that feed those algorithms. We must continue to question what makes some members of our community more susceptible to either surveillance or subjection to the use of automated decision-making and other AI tools, and whether the law is complicit in not addressing those issues. We must be attentive as well to the biases that shape whose privacy we protect and the extent to which we do so. And while we might be ready to congratulate ourselves for having finally plugged the voyeurism gap in privacy law, it was only recently that both the Ontario Supreme Court and the majority of the Ontario Court of Appeal acquitted a high school teacher of the newly minted crime of voyeurism after he used a hidden pen camera to surreptitiously film down the tops of his female students. The child judge was not, and I quote, "satisfied beyond a reasonable doubt that the only rational conclusion is that the limited pen camera images of the female student's cleavage or breasts were made for sexual purposes." Okay. The majority of the Court of Appeal were unable to find a reasonable expectation of privacy by these students in schools, as the schools were public places and ones in which there were already other forms of surveillance. The Supreme Court of Canada's 2019 decision in this case, R versus Jarvis, is truly a watershed moment in Canadian privacy law. A majority of the court articulated a far more contextualized understanding of privacy, both in terms of spaces and relationships.
While acknowledging that expectations of privacy will generally be at their highest when a person is in a traditionally private place from which she has chosen to exclude all others, Chief Justice Wagner nonetheless affirmed that a person does not lose all expectation of privacy because she is in public. He stated, "A person may be in circumstances where she can expect to be the subject of certain types of observation or recording, but not to be the subject of other types." He continued, "Being in a public or semi-public space does not automatically negate all expectations of privacy with respect to observations or recording." Further, he maintained that the impact of new and emerging technologies needs to be carefully considered. It is possible that technology may allow a person to see or hear more acutely, thereby transforming what is reasonably expected and intended to be a private setting into a setting that is not. The majority also noted that, and I quote, "The reasonable expectation of privacy is a normative rather than a descriptive standard." This means that a person's expectation of privacy should not be determined simply on the basis of whether there's a risk that they might be observed or recorded. If this were the case, advances in technology would shrink the reasonable expectation of privacy to nothingness. As a result, the majority framed the core question as whether the person was in circumstances in which she would reasonably have expected not to be the subject of the observation or recording at issue. The importance of the Jarvis decision will echo beyond the criminal law context, and in fact, it already has done so. The Supreme Court has signaled a more contextual approach to privacy that focuses on the core issues of human dignity and autonomy and less on whether someone is in a traditionally public or private space. It's a decision that's sensitive both to the impact of technology on privacy and to the need for a concept of privacy that understands the contextual dynamics of age, authority, gender, and power in understanding how one came to be in the place in which one was observed and recorded. The importance of this development cannot be overemphasized. If privacy is a human right, it cannot be one based on notions of private property and patriarchal relationships. But it takes considerable work to unpack this old baggage. And when we talk of ensuring that there is no bias in the data that feeds AI algorithms or that the algorithms themselves do not incorporate bias, this case law is an important reminder of how deeply entrenched biases may be and how they shape not only our understanding of processes and procedures, rights and entitlement, but how they also shape those systems that we put in place to ensure that human rights are respected. It's important to acknowledge here that we are now directly challenged as a society to confront systemic racism, and that this will not be a simple process. In the privacy context, it will require us to address who is surveilled and for what purposes, and how the data we collect or do not collect impacts automated decision-making and the development and use of AI technologies such as facial recognition. And while ethical AI frameworks all acknowledge the importance of eliminating bias in algorithms and data, this is a complex task. I'm going to use this as my justification for now talking about a Supreme Court of Canada decision that was not about privacy in order to make a last point about the history of privacy and the future of AI. The case is about impartiality and bias. At a more fundamental level, it's about how our lived experiences inform how we make sense of the world around us, and about how it has been that some lived experiences become objective reality while others remain subjective and biased. The case is R versus RDS, and it was decided by the Supreme Court of Canada in 1997. The dispute originated in the trial of a 15-year-old Black youth in Nova Scotia. He had been charged with unlawfully assaulting a police officer and resisting arrest. Only he and the police officer were witnesses to what happened between them. The trial took place before Judge Corinne Sparks, the first Black woman to be appointed to the bench in Canada, and the first Black judge ever appointed in Nova Scotia. In providing oral reasons, she addressed the prevailing social context in which police officers had been known to mislead the court in the past and had been known to overreact, particularly with non-white groups. These words launched a challenge against the judge and her decision, alleging bias. The Nova Scotia Supreme Court and a majority of the Court of Appeal both ruled that the remarks created a reasonable apprehension of bias. A majority of the Supreme Court of Canada ruled otherwise. Justices Leroux-Dubé and McLaughlin, the only two women on the court at the time, wrote that they found Judge Sparks's comments, and I quote, "to reflect an entirely appropriate recognition of the facts in evidence in this case and of the context within which this case arose, a context known to Judge Sparks and to any well-informed member of the community." They noted that, and I quote again, the reasonable person is cognizant of the racial dynamics in the local community and as a member of the Canadian community is supportive of the principles of equality. By contrast, Justice Major for the 3 dissenting justices wrote, the trial judge presumably called upon her life experience to decide the issue. This she was not entitled to do. R versus RDS rocked the legal world because a Black woman judge used her knowledge of the social context to frame her understanding of the facts. Because her knowledge differed from the dominant account, it seemed to many that it had to reflect bias. I would note that of the 13 judges that heard this case all the way up to the Supreme Court of Canada, 6 found bias. Of the 7 that found no bias, 1 referred only briefly to the racial perspective. 3 found that Judge Sparks skated pretty close to the line, and only 3 explicitly recognized that our ideas of objectivity and neutrality rely upon the perspectives of the dominant group defined by race, gender, privilege, and other factors. The difficult work that needs to be done to understand and build upon R versus RDS is the same work that we need to do to understand how the laws that frame privacy rights, the data on which AI is built, and the algorithms that power it are all products of the hidden assumptions and priorities of those privileged to understand the norms, collect the data, and write the algorithms. In this context, privacy law has to be more than just a set of rules governing consent to the collection and use of data. It must be acknowledged as a fundamental right based on a robust concept of autonomy and dignity, interlinked with the right to equality and the right to be free from discrimination. The laws enacted to support this human right to privacy must serve these goals and these principles and must be subject to the same critical inquiry as the algorithms and data they will govern. This is where the history of privacy has brought us, and if we are able to act upon it, it will shape in fundamentally important ways the future of AI. Thank you very much.